Sorry, I do somewhere. Raise your right hand, let's place you under oath. You solemnly swear or affirm the testimony you're about to give in this case will be the truth, the whole truth, and nothing but the truth, so help you God. All right, thank you. Have a seat. Speak directly into that microphone, please.
Are you Sergeant Justin Stewart with Dixon Police Department?
Yes, ma'am.
Would you spell your first and last name for our court reporter?
Yes, ma'am. First name Justin. Last name Steward as in Dave.
On June 18th, 2022, were you working in your capacity as law enforcement?
Yes, ma'am.
And you were actually out on scene assisting Javens at the original call.
Yes, ma'am.
And that was the first time that night that you saw the defendant.
Yes, ma'am.
Did you see him again that night?
Yes, ma'am.
Could you explain to the jury where you saw him and what got your attention?
Yes, ma'am. So, am I allowed to talk on the video that's been played? So, or did they see the whole thing? Or?
So let me walk you through a little bit more. So
Okay.
they're aware of what the call was about, but you, and let me just help you to the point that we're at. Did you go back to the jail later that night?
Yes.
Did you going back to the jail have anything to do with the defendant?
No, ma'am. In fact, what I was going to mention is that whenever she called for units to step it up, I was en route to another call for a warrant service. So once her call concluded, I then went to the call that I had told her about, and we made an arrest, and that's how I had contact with him again. So
The warrant service means someone has an outstanding warrant and you're going
Yes.
to serve it.
yes.
Okay, so you serve that warrant, you take that person to the jail. What happens next?
So at the time, I believe I was still a corporal then. I had a recruit Floyd with me. So whenever we have recruits that are in training with us, we kind of slow down some of the paperwork as far as, where originals go, where copies go, things like that, standard training things. So once we concluded business with the subject that I arrested, who was cooperative, we served as warrant advisors, court date, etc. We made copies of all paperwork, and then jail staff kind of took him away. Our business was concluded. So unfortunately, at that point, that's where we turn off our body cameras, right? And Mr. Vaughn was out in the, I guess you could call it the common area on the male side and booking, and was still upset and made a comment that he had bullets for all of us or something to that effect. And I simply mentioned to Corporal, I believe at the time, Javens, when we got back to the police department, she just needed to notate that in her report, just in case in the future, she were at Walmart or wherever, and he were to actually try to follow through with those threats. So.
When someone makes a threat like that, is it common for law enforcement to note it in your paperwork?
It should be.
And you said in case she sees him out in public. What do you mean?
I mean, if she's out with her family at Walmart or the movies or anything, and he actually intended to follow through on them and cause harm to her, and she had to defend herself, we would have documentation that she wasn't just out looking for a conflict, that threats were made, and that's obviously something we take seriously, and I believe would put any of us on edge. So.
Did his remarks put you on edge?
Of course, yeah, it's always uncomfortable. That if not, I wouldn't have made it a point to go back and mention it to her that this is worth documenting. It's concerning. You're threatening, officers, and
to the best of your recollection, what were his words?
I believe that it was, I have bullets for all of you, or I have enough bullets for all of you. That's essentially what it was. So.
Nothing further, Judge. Well, actually, I'm sorry. About how much time would have elapsed between the end of Javens's call and when you were there?
When I returned to the jail?
Yes, when you returned and you heard these statements from the defendant.
So I can guesstimate, or If I'm allowed to use my phone, I can get the exact time. It's up
A
to you.
guesstimate is fine.
Maybe hour and a half, if I had to guess, ballpark.
So at least an hour, no more than 3 hours.
That sounds reasonable.
Thank you. Nothing further.
Mr. Vaughn, do you have questions for this witness?
Yes, sir. One moment, please. How you doing?
Doing good. How are you?
Corporal Stewart.
Yes, sir.
Oh,
Stewart.
Sergeant Stewart now.
That's all right. That's all
All
right.
right. When you entered that jail that night, did you have your body cam on?
I would have whenever we entered with the other party that I had after the fact, if that's what you're asking about, the arrest warrant that I referenced.
Did you manually turn off your body cam?
Yes, once business is concluded with the person that we're interacting with, that's standard, yes.
Said you. And you testified previously that Corporal Javens was not specifically mentioned in these statements, correct?
That's correct.
Okay. And you were also on scene when I was arrested, correct?
Yes,
But you're not named as a victim here today, are you?
that's,
I believe that'll be all, Your Honor.
All right.
Per Rule 29 of Criminal Procedures, a motion for a judgment of acquittal, taking the facts into light most favorable to the state. No reasonable jury can conclude that I am guilty beyond a reasonable doubt of this charge. Your Honor, no statements were made directly to anybody. There's no harm that was done to anybody. To add insult to incident, 5 months delay, there was no carry out of these allegations of the statements I made. The intent was never there. And I believe with all the evidence that I showed to the jury, they would be acquitted, Your Honor.
All right, thank you. You wish to respond, General? Mr. Vaughn, I'm going to ask you to be placed under oath for the limited purpose of us conducting this, what's called a Momon hearing, and that is where I question you about your intentions to, I'm going to go over it with you, and then if you'll raise your right hand, let the clerk place you under oath.
Fine.
All right, Mr. Vaughn, you are, understand, and I want to make sure you do understand, that you have a right to testify in this trial on your own behalf. And if you want to testify, no one can stop you from testifying. Do you understand that?
Yes, sir.
You also understand that you don't have to testify. No one can make you testify against your will. And if you don't choose to testify, the jury cannot draw any inferences from the fact that you did not testify. And in fact, the burden remains on the state to prove your guilt beyond a reasonable doubt as they've been instructed, regardless of whether you put on any proof or call any witnesses or testify. Do you understand all that?
I understand.
Have you talked this over with your advisory counsel, Mr. Spratt, and discussed with him the advantages and disadvantages of whether or not you want to testify?
Yes, sir, I have.
And do you believe it's in your best interest to testify or not to testify?
I believe it's in my best interest not to testify, Your
All
Honor.
right. Then upon your decision not to testify, I'm going to ask you to sign this form. Mr. Spratt, I realize that you are advisory counsel, but I'm going to ask you to sign as advisory.
Could you state your name for the record, please?
Jennifer Nicole Dozier,
How do you know me?
20 years and 3 kids.
Okay,
Pull
so,
that microphone towards you a little bit, please. There you go.
And we have 3 kids together.
are you familiar with this case here today?
Yes.
The initial call that the police were called for, are you familiar with that?
As we were arguing,
Yes. What did they say it was when I got to the scene?
we were arguing in Walmart.
Okay. Are you familiar with the statements that were made, the reason they came?
I don't remember. It's been years.
Well, the statements that were made were statements that I could cause harm to someone in the vehicles or to yourself. Do you believe that it was possible that I could cause harm to you?
No, not in that moment. We were arguing over a birthday cake.
Do you think I'm someone that should people be scared of?
No,
Would you think I'd be the type of person to retaliate on somebody or dwell on things?
not to my knowledge. Not that I've seen you do in 20 years, but
One of the charges that I was arrested for was resisting arrest. I don't think that's a good question, but I'm gonna ask it. Do you believe I should have been charged with resisting arrest?
well, no, but the charge was dropped, correct?
Yes, it was.
So,
Do you believe I should have been charged with that? Do you feel like I resisted in any way?
no,
From your own knowledge, there was other people in the car, correct?
for children?
Are they well capable of speaking English and understanding English?
Yes,
Do you think that if they were in fear that they would have spoken up if asked?
yes,
You were being their mother. Do you believe my kids are in fear of me?
I mean, you're their father. They're supposed to be in fear of you at times, but
Okay. Do you think that they would think I would harm them?
no,
Do you believe that the arresting female officer on the scene, do you believe that she addressed the issues to the best of her authority, you think?
I think she did.
You think she
I mean, I
did?
think maybe she could have called a male officer, but they could have been shorthanded that night. We don't know what was going on.
Okay. I think that would be all, Your Honor.
All right. State, have any questions?
Judge, I'm going to need a jury out before we have questions.
Ladies and gentlemen, if you'll step out across the way, I will need to take up a matter in your absence. The rule, the court rule is he elected to represent himself. And with that, as I asked him, if he had familiarized himself with the rules of evidence and so forth, then it becomes imperative on his behalf to make sure he's familiar with. And of course, he's quoted in the pleadings he filed that we had motions on, numerous case law, or numerous cases, a lot of case law, a lot of rules. He's cited rules today. And there's a line at which he's responsible for whatever he chooses to do. And he was advised he would be held to the same standard as a lawyer. Clearly, a lawyer who asked the questions that he asked about his client opened the door to the question of whether or not. Right now, the jury has heard this witness say, oh no, she doesn't think he's the kind of person who could do that kind of threat. That's a very material issue in the case having to do with a threat of retaliation for past action. The very gravamen of which is that he is capable of making that argument. So the state has the right to now produce evidence to show that this defendant, through this witness, is capable of such actions if he has in fact been convicted of other crimes. My intention is to allow this evidence to come in and to give the jury a limiting instruction. Their instruction will be that they are to consider this evidence only as it goes to the credibility of this witness's testimony regarding her belief that he is not capable of such, he does not pose a threat and is not capable of that type of action.
I understand the court's ruling that.
No, we're moving forward. The reason is, it's not going to make any difference whether you have 5 minutes. You can sit there and have 5 minutes with him, but the fact of the matter is that we're moving forward with the questioning of this witness, and Mr. Vaughn you can consult with him, but it's not going to change my ruling. All right, General Bryson, question the witness as to what the question, ask the questions you're going to ask in front of this, in front of the jury of this witness.
Judge, while this will not be the full cross-examination, the pertinent questions will be, Ms. Dozier, are you familiar that the defendant was convicted of aggravated assault in November of 2016?
Yes,
Are you familiar that he was?
Objection, Your Honor. Basis
have-
knowledge.
We are having a hearing, Mr. Vaughn, and for me to determine, the jury's not here. We're having a hearing for me to determine whether or not this evidence should or should not come in. So you just sit quietly. I'll give you a chance to question, to make your argument or through your counsel. I'll let you make the argument. Go ahead.
Are you aware that he was also convicted of 2 counts of aggravated robbery in 2016?
I am.
Are you aware that he was convicted of aggravated assault in 2011?
I am.
Those are the questions, Your Honor.
Your Honor, the questions that I were asking were pertaining to retaliation. And to the best of my knowledge, I believe she doesn't know nothing about the convictions of the defendants. I can ask her yourself for the record, Your Honor, if you want me to. Ms. Dozier,
No, we're not asking her any more questions. Now we're talking about the fact of whether or not this evidence should or should not be admitted. I'm giving you a chance to tell me why it shouldn't be admitted.
because the questions I was asking was pertaining to harm to the children and pertaining to retaliation of past acts. She doesn't have any knowledge of my convictions.
You ask her the question.
So
You ask her the question.
I'm asking her questions from the time that me and her was together at these charges, Your Honor. She doesn't have no true knowledge of them charges. Me and her wasn't even together when them charges happened, Your Honor.
Well, that may be, but she just testified on direct with General Bryson that she was aware of all of those convictions.
She wasn't given a copy of none of that. Yeah, I don't believe it should be used, Your Honor.
All right, thank you. Court is going to allow the state to ask the questions, and I will simply limit your question to, is she aware of the fact that he's been convicted of aggravated assault and aggravated robbery in the past, without going into the multiple counts of aggravated assault? I don't think there's any reason for doing that. I think you can establish what you're trying to establish by simply referring to his prior conviction, if she's aware of the fact that he has a prior conviction for that. I still intend to instruct the jury that I'm allowing this information over the objection of the defense for the sole purpose of testing the credibility of this witness and her testimony as to, in response to the questions the defendant himself had asked about whether or not she thought he was capable of these things. Bring the jury in. Ladies and gentlemen, outside of your presence, I consider it an objection that was made to some testimony that was going to be offered. The state is about to ask some questions of this witness. I am allowing the state to ask questions that, because of the fact that the defendant asked this witness questions about her belief as to whether or not he was capable, you'll remember what was the questions were, whether or not he was the kind of person that would have posed a threat and so forth. So the state is now seeking to rebut that testimony by offering questions of this witness regarding some other matters. I'm allowing it to be introduced solely for the purpose of testing the credibility of this witness on the issue on her testimony in response to the defendant's question. You should not consider the evidence you're about to hear on the issue of guilt or innocence per se, but only on the issue of the credibility of her testimony about whether or not he poses a threat or he posed a threat and so forth. So the state may now cross-examine the witness.
Ms. Dozier, you testified that you and the defendant have been together for 20 years?
On and off.
On and off. And you have 3 children together.
I do.
What are their ages?
17, 15, and 12.
And you testified that the defendant was not capable of harm. Just yes or no?
I did.
Okay. And you are aware that the defendant has previously been convicted of both aggravated assault.
Objection, Your Honor. Basis of knowledge, ask the witness to lay a foundation. Basis of knowledge, Your Honor.
Overruled.
You are aware that the defendant has been previously convicted of both aggravated assault and aggravated robbery.
I was where he's arrested on him. I didn't attend his court proceedings, but I knew he went to jail, of course, or prison. Excuse me.
Nothing further, Judge.
Redirect of this witness.
To the best of your knowledge, have I ever retaliated to anybody in these charges?
Not to my knowledge, no.
To the best of your knowledge, was any of them hurting any kids?
No.
Okay, thank you.
Thank you, ma'am. You may step down. You may have a seat in the courtroom or you may leave. Mr. Vaughn, you may call your next witness.
Defense rest, Your Honor.
All right. State, have any rebuttal proof?
No, Judge.
All right, ladies and gentlemen, you've heard all of the evidence that you are going to receive to be able to decide this case. The next step is for the lawyers or the state and Mr. Vaughn to make their closing argument. I would remind you that the closing arguments, both of the state and of Mr. Vaughn, are not evidence. They are not testimonial. They are not evidence. They are simply their argument to you about what they think the case has proven. So therefore, we'll let the state go first, and they have the right to go first and also to close after the defense.
Ladies and gentlemen, put before you today is to decide a very narrow set of facts, whether or not the defendant on June the 18th in 2022 knowingly threatened to harm Officer Lindsay Javens by any unlawful act in retaliation for anything Officer Lindsay Javens did in an official capacity. On that night, Officer Javens arrested the defendant and took him to the jail. When they got to the jail and you were able to listen to the video and you have the transcript from Officer Javens, it's up to you to decide what you think was said on that video. The transcript is an aid to help you. But the state would submit the following statements demonstrate very clearly that the defendant knowingly threatened Officer Javens for her arrest of him that night. I am a threat. I am a threat for a reason. Officer Javens will say, you kind of just threatened me, but it's cool. And the defendant says, you can take it anyhow you want to. I don't care about none of that. When they begin to take the cuffs off him, notice what he said. Don't take them off right now. Don't do it. He says, Lindsay, if that's your real name, you done lied to me. I done told you I don't trust women for a reason. Stop talking to me. As they begin to get the cuffs off of him, he says, when her jaw gets broke, it's your fault. Okay? He then screams, lion ass hoe. Okay, he's accused only one person of lying. That is the officer. That tells you who he is directing this tirade at. It's directed at her because he's decided that she's lied to him. He then says, and ladies and gentlemen, I'm going to use his words because those are his words that you saw in the video. The female says to him after he says lion ass hoe, the other female in the room says, hey, we are trying to get the cuffs off of you so you can stop tensing up, please. And Vaughn responds, fuck no, because I'm going to beat that bitch up. Bet on that. As he's going into the cell, he turns to this officer and tells you about something she already told you in their earlier conversation. He says, you laughing? You live in Dixon, Fairview, you talk too much. And then he continues on once he's placed in the cell. Ain't none of y'all safe without a goddamn badge. And then an hour and a half, 2 hours later, he is still speaking in the vein of these threats he's already made, as he says, where Corporal Stewart hears it, he's got enough bullets for all of you. Law enforcement should be able to do their job based on the facts and law in front of them and with no fear of retaliation for what they've done. That is why threats are enough. The officers told you they documented these because these statements might become relevant later on. That tells you the mental effect that these threats had on law enforcement. That tells you that they perceived them as serious, that they perceived the defendant could act on them. And under the law, it is the threat alone that is enough for punishment. Is everyone here very thankful that these threats were not acted on during that time span? Yes. But this isn't an assault charge. He doesn't have to have hit her in that moment. This is a charge for retaliation for past action, and it goes to the threat that were a direct response to her action as law enforcement.
With all the evidence that is shown here today, can we say that we're happy about what happened? No. Can we say that we believe that we should be charged with something like that? No. If the charge should be, I should be charged with something like that, I believe it should be immediate. I made bond probably 12 hours afterwards on the street, went and opened up a business. Actually had a first responders meal for $8 out on a food truck. I build houses too in the community.
Judge, I'm sorry, the defendant has opted not to testify and is
Well,
stuck.
You can make an argument about what the testimony has been in this case and the interpretation of that testimony, but you cannot testify, which is what you're doing now. I sustain the objection. Jury will disregard.
Okay. Be honest, like, who hasn't cussed a police officer out before? You get pulled over for a ticket, whatever, I don't care what it is. They get on your nerves just like they get on my nerves. I'm an American. Did I do something? No. Did I speak in writing? That's debatable. It wasn't even direct. Throwing stuff out in the air, should you be, everybody in here probably said something. Every one of y'all should be charged with it if you ask me. With the evidence provided you, I've also shown that if it wasn't for the fact I was even arrested in the first place for a charge that they chose to dismiss, a charge that y'all didn't even hear today, this charge wouldn't even been put on me in the first place. I've also took the charge of driving on revoke, which I had very good arguments for that. Documents I could have put in today, but just to show y'all that I was being honest about the situation, just to gain some value with y'all, to be honest with you. To shorten this time with y'all being here so y'all can get back to y'all families. So looking at all the facts that were stated, the officer, there was no fear. This was just retaliation because she couldn't get me for nothing else. It's just simple as that. She's laughing, antagonizing. Really, if you ask me, just going outside of her way, if you ask me personally. I'm hoping y'all see it in the same light I was seeing it in. You've heard the statement from my children's mother. She was present. The children were present. None of them feel any harm. They wanted to go home with me. You heard that in the video. I think this was blown way out of proportion. If I was a threat, I had plenty of time to do it. If it was that big of a deal, besides taking a note of it, why wasn't I arrested and charged with it then? Bottom line. It shouldn't be something to be dragged out. If you want justice, do justice then. It's simple as that. I believe I got, that's all I got for y'all. Thank y'all.
Colonel Bryson, do you have any final say?
No, Judge, I'll stand on my argument.
All right, then let me have one of you pass this out to the jury. All right, ladies and gentlemen, if you'll follow along with me. The defendant, Shereef Mark Vaughn, is charged in the indictment with the crime of retaliation for past action. The defendant pleads not guilty to the indictment and to the offense contained therein. The evidence and arguments in this case have been completed, and it is my duty now to instruct you as to the law. The law applicable to this case is stated in these instructions, and it is your duty to carefully consider all of them. The order in which these instructions are given is no indication of their relative importance. You should not single out one or more of them to the exclusion of another, but should consider each one in the light of and in harmony with the others. The law presumes the defendant is innocent of the charges against him. This presumption remains with the defendant throughout every stage of the trial, and it is not overcome unless from all of the evidence in the case you are convinced beyond a reasonable doubt that the defendant is guilty. The state has the burden of proving the guilt of the defendant beyond a reasonable doubt, and this burden never shifts, but remains on the state throughout the trial of the case. The defendant is not required to prove his innocence. Reasonable doubt is that doubt created by an investigation of all of the proof in the case and an inability after such investigation to let the mind rest easily as to the certainty of guilt. Absolute certainty of guilt is not demanded by the law to convict of any criminal charge, but moral certainty is required, and this certainty is required as to every element of the proof necessary to constitute the offense. The state must prove beyond a reasonable doubt all of the elements of the crime charged, that the crime, if in fact committed, was committed by this defendant in Dickson County, Tennessee, and that it was committed before the finding and returning of the presentment in this case. The burden is upon the state to prove by a preponderance of the evidence that this offense was committed in Dickson County, Tennessee. Proof by a preponderance of the evidence means that the greater weight of the evidence must be in support of the state's contention. Venue of the offense lies in the county where the offense was commenced or consummated. If you find the state has failed to prove by a preponderance of the evidence that this offense was commenced or consummated in Dickson County, Tennessee, then you must return a verdict of not guilty. As heretofore stated in the indictment, the defendant is charged with the crime of retaliation for past action. For you to find the defendant guilty of this offense, the state must have proven beyond a reasonable doubt the existence of the following essential elements. 1, that the defendant threatened to harm the alleged victim by any unlawful act, and 2, that the alleged victim had been a law enforcement officer. 3, that the defendant did so in retaliation for anything the law enforcement officer did in an official capacity as a law enforcement officer, and 4, that the defendant acted either intentionally, knowingly, or recklessly. Intentionally means that a person acts intentionally with respect to the nature of the conduct or to a result of the conduct when it is the person's conscious objective or desire to engage in the conduct or cause the result. Knowingly means that a person acts knowingly with respect to the conduct or to circumstances surrounding the conduct when the person is aware of the nature of the conduct or that the circumstances exist. A person acts knowingly with respect to the result of the person's conduct when the person is aware that the conduct is reasonably certain to cause the result. Recklessly means that a person acts recklessly with respect to circumstances surrounding the conduct or the result of the conduct when the person is aware of but consciously disregards a substantial and unjustifiable risk that the circumstances exist or that the result will occur. The risk must be of such a nature and degree that its disregard constitutes a gross deviation from the standard of care that an ordinary person would exercise under all of the circumstances as viewed from the accused person's standpoint. If you find the defendant guilty of retaliation for past action as charged in the indictment, you shall so state. On the other hand, if you do not find the state has proven beyond a reasonable doubt the guilt of the defendant, or if you have a reasonable doubt as to his guilt, then you shall acquit the defendant of this offense. It is your duty as jurors to consult with one another and to deliberate with a view to reaching an agreement if you can do so without violence to individual judgment. Each of you must decide the case for yourself, but do so only after an impartial consideration of the evidence with your fellow jurors. During your deliberations, do not hesitate to re-examine your own views and change your opinion if convinced it is erroneous, but do not surrender your honest conviction as to the weight or effect of the evidence solely because of the opinion of your fellow jurors or for the mere purpose of returning a verdict. The verdict must represent the considered judgment of each juror. To return a verdict, it is necessary that each juror agree thereto Your verdict must be unanimous. You can have no prejudice or sympathy or allow anything but the law and evidence to have any influence upon your verdict. You must render your verdict with absolute fairness and impartiality as you think justice and truth dictate. When you retire to the jury room, you will first select one of your members as foreman or forelady who will preside over your deliberations. When you have reached the verdict, you will return with it to this courtroom and your foreman or forelady will announce it. In reaching your verdict, you shall consider the offense charged in the indictment. If you unanimously find the defendant guilty of the offense beyond a reasonable doubt, you shall return a verdict of guilty for that offense as to the defendant. On the other hand, if you find that the state has not proven beyond a reasonable doubt of the defendant's guilt, or if you have a reasonable doubt as to his guilt, then you must find him not guilty. In that event, your foreperson will report that you found the defendant not guilty. If after your deliberations you find the defendant guilty, the court will set the punishment at a separate sentencing hearing. The jury will not be involved in setting the punishment. You may now retire for your deliberations. Ladies and gentlemen, I have had prepared a verdict form that will help you in your decisions. It basically is just in the indictment for the charge of retaliation for past action, we, the jury, find the defendant, Shereef Mark Yvonne, either not guilty or guilty, and then signed by the foreman or forelady. And let me sign that. Before we send you back, I need to select the alternate, and the person that's selected as the alternate will be excused from any further participation. You may leave or you may wait around and see what your fellow jurors decide. So, let me get a paper clip.
All right, let's talk about that. Watching guide the close of S trial was like watching someone steer a ship through choppy waters. Vaughn pushing self-defense and overreach, the state hammering retaliation, and Wolfe keeping it squarely within law and credibility. The session opened with Sergeant Justin Stewart's testimony. He recalled Vaughn, hours after the arrest, still agitated in booking and saying he had bullets for all of you. Stewart admitted body cams were off at that point, but emphasized that such remarks were serious enough to document because officers worry threats could be carried out later, even at Walmart with family in tow. To him, the words put everyone on edge, resenting himself, tried to spin this as vague and non-specific. On cross, he pressed Stewart. Javens wasn't named, right? Stewart agreed she wasn't mentioned directly. Vaughn argued that without naming her, or acting on it, there was no retaliation, just heated words. He moved for acquittal, insisting no reasonable jury could find intent. Wolfe denied it, but carefully explained Vaughn's rights. He didn't have to testify, the jury couldn't hold silence against him, and the burden remained on the state. Then came from Vaughn's longtime partner, Jennifer Duggar, mother of his 3 kids. She painted him as argumentative but not dangerous. We were arguing over birthday cake. I don't believe he'd retaliate or dwell on things. Vaughn used her to show that even his family didn't see him as violent. But Wolfe cautioned him, by opening that door, the state could rebut with prior convictions. And they did. Prosecutors asked Duggar if she was aware of his 2011 aggravated assault and 2016 aggravated robbery convictions. She admitted she knew he'd gone to prison. Wolfe instructed the jury this wasn't proof of guilt now, but only to weigh the credibility of Duggar's claim that Vaughn wasn't capable of threats. Closing arguments, see, he divide. The state walked the jury through the body cam and testimony. Vaughn saying, "I'm a threat for a reason. When her jaw gets broke, it's your fault. Fuck no, I'm gonna beat that bitch up." They argued it was clear retaliation against Officer Javens for arresting him that night, and that the threats were enough. He didn't need to act on them. Vaughn, in his own closing, told jurors it was blown out of proportion. Who hasn't cursed at cops, he asked. He pointed to his food truck business and his kids' lack of fear. His argument, this was payback for a false arrest, not real threats. Wolfe's final instructions were cease. He laid out the elements. To convict, the jury had to find that Vaughn threatened to harm Officer Javens in retaliation for her official actions and did so intentionally, knowingly, or recklessly. He reminded them the state bore the burden beyond a reasonable doubt, and their verdict must be unanimous. No sympathy, no prejudice, just law and facts. What stood out was Wolfe's balance. He let and testify indirectly in closing before cutting him off, but he never lost control of the frame. He allowed prior convictions in, but tightly limited their purpose. And he closed by giving jurors a roadmap, presumption of innocence, reasonable doubt, and the elements they had to weigh. It wasn't about theatrics. It was about discipline, clarity, and letting the jury, not the drama, decide. If you found this hearing insightful, consider subscribing, hitting the bell, and letting me know your thoughts in the comments below. I read every one.